right, great. So we have like 49, 50 people on today, which is awesome. Happy Friday. And before we get started, I want to drop a footnote so I don't forget. We're supposed to get a cold snap tomorrow, so we're getting our first taste of fall. But it's not going to be this cold. But I want you all to keep in mind that as we creep towards winter, keep in mind we have to confirm, especially if attached units, that vacant units have been winterized. Vacant units have been winterized. Every fall we go into winter, and then we get phone calls, panicked phone calls by managers, sometimes on the weekends, that water is flowing out and under the doorways of units because the pipes are frozen and then they have thawed and water is being pumped out through the unit. So keep in mind as we cruise into fall here that vacant units are winterized, whether they're vacant units and they're in foreclosure, what have you, or you have a whole bunch of snowbirds there who may have not realized it and turned their heat off and left their pipes on. So that's always a major issue. Certainly if you're in a mid-rise or high-rise, that's a crucial issue because you can flood entire columns of apartment style units. So anyway, so nice to see you again. We'll do dogs of the day quickly. So we have dogs of the day. We're back to dogs. Thank God. I'm perfectly fine with cats, but I am a dog fan. So today we have Henry and Lucy. Henry's on the left there, and Lucy's on the right, and they are in their Halloween costumes. Nice to see you, right? So Henry is in the prisoner costume, and Lucy is in, it looks like the pink lady costume with the poodle skirt for those who were around in the 50s, right? The Frankie Valli generation, if you will, maybe even before the Frankie Valli generation, the Happy Days generation, I suppose. And so the dogs were submitted by Bonnie Hendricks, who is a senior manager at Executive Property Management. So thanks, Bonnie. I don't know if you're out there or not, but thanks so much for sending in the dogs. Nice to see the dogs again. So that's dog of the day. And I have to do my little legal announcement again. I know this is always annoying. The webinars are provided for general informational and discussion purposes only. They do not and cannot create an attorney-client relationship. The information exchanged does not constitute legal advice. To obtain legal advice, you must contact your attorney directly, enter into a retainer agreement, and present your particular facts, right? Because we don't know if the facts here are just for discussion and educational purposes. The information discussed will not be kept confidential. So again, don't be putting any crazy stuff in the chat or saying crazy stuff over the voice if you're off mic, because we won't keep it confidential. What's up, Marcos? Long time no see. Good to see you. And so let's roll with it. Today's going to be pretty quick. Keep in mind, with very, very few exceptions, when it comes to officer positions, it's one person, one vote on a board, right? So this is not like the President of the United States, where the president has some extraordinary powers to do crazy stuff, or even in some local governments, where the mayor may have extraordinary powers over the township committee. Just for those of you who are not into local government, New Jersey has 5, 6, 7 forms, something like that, of local government. Some of them are what's called a strong mayor form of government. Others are a committee form of government, which they call a weak mayor, where it is more or less a one person, one vote system. But in community association world, it's generally a one person, one vote. So we usually don't go down that road of the president having any extraordinary powers unless the board gives them those powers, right? So generally speaking, so we have 2 acts, right? 2 acts in New Jersey that relate to what we're talking about. One is the Corporations Act, which generally addresses for-profit corporations. Why do we care about that, Fran? We are not-for-profit corporations. The reason we care about that is most of the case law under these corporation type issues are litigated in the for-profit corporation context. You see what I'm saying? So generally speaking, the not-for-profit organizations aren't going to spend hundreds of thousands, if not millions of dollars on litigation as to the scope of a board president's authority, right? So even though we are under the Nonprofit Corporations Act, meaning the associations are, if you're going to be doing research under the Nonprofit Corporations Act, many of the statutory provisions are very similar, but you won't see case law cited on those provisions, right? Because the litigation and the cases that come out of this area are litigated under the for-profit corporation. So we argue these cases by analogy under the For-Profit Corporation Act. Okay, so here we're under the Not-for-Profit Corporations Act. It's 15A:6-15. And what do they care about in terms of officers? I know, hi, Patty. I don't, are we in the chat, Patty? I don't know. So the three main important, if you will, officers in an association's board or in a corporate board for that matter are generally the president, the secretary, and the treasurer. And they're the primary ones that are referenced in the Not-for-Profit Corporations Act. Okay, so the Not-for-Profit Corporations Act says you basically need a president, a secretary, and a treasurer. And without getting to the nuances and the exceptions with respect to this, there are times when one person can serve in two roles. Okay, so that becomes a debate. Sometimes that's not always the case. There are some prohibitions on that. I'm not going to get into the prohibitions right now, but sometimes people do serve in two roles. More often than not, it's because they don't have anyone else to serve in those roles. I'm going to share screen for a moment, and I'm going to give you an example from governing document provisions in one of the associations we work with that actually spells it out. Many associations, governing documents do not spell out the roles of the president, the vice president, the secretary and the treasurer, but these do. So I'll flip to this real quickly here. I don't know if you can see that. So you have 703, the president is the HOA's chief executive officer and presides at all member and board meetings. In our world, generally speaking, what the president does is preside at member and board meetings, right? And that's usually the most, we'll call that visible role of the president, right? The president has the general powers and duties usually vested in the office of the president of an HOA, really awful language, including but not limited to power to appoint committees from the members from time to time, et cetera. So in this association, this was set up so that the president could appoint committees. In most associations, the president does not appoint the committees. The board itself appoints the committees, creates the committees, adds people to committees, and removes them to committees. The power to execute deeds, contracts, and other instruments. However, keep in mind, the power to execute deeds, contracts, and other instruments does not mean that the president can just make the call and contract with people or execute deeds because she feels like it. No, it's a board action. It's just the president is the one who actually executes these instruments on behalf of the association. But it has to be under the authority from the board. Okay, does that make sense? Some board presidents believe that they can just do things because they're the board president. With very, very limited exception, it has to be board action, right? Unless the board has given the president that power. So here we see the secretary. The secretary attends all board meetings, records all votes, takes and keeps all records of the meetings, resolutions, minute books, etc. Performs those duties for committees if that's the way your community is set up. Keeps the list of members up to date, etc. So it's basically the secretary is responsible for the books and records of the association. Similarly, the treasurer is responsible for the homeowners association's funds, securities, investments, accounting books and records, disbursements, all those other wonderful things. I'm going to stop the share there, but that's just an example where they're expressly stated. The other thing that comes up here, stop the share, and I may have mentioned this one other time, the treasurer in that language in those governing documents says the treasurer is responsible for the HOA funds and securities, keeps full and accurate accounts and receipts. I may have told you probably about 15 years ago, I represented a homeowners association in Hamilton Township where I was fired because I got in a scrape with the treasurer of the association who insisted that language means he personally has to keep the books and records of the association, even though they had a prominent management company as their management company. His theory was, no, Fran, the language says what it says, and I can't use the management company's bookkeeping personnel to do that work. I mean, I don't know why, but it seemed pretty evident to me across the entire industry that many associations use professional management companies, professional accounting and bookkeeping staff to do that job. So just because the language in your bylaw says that's the um, job of whether it's the secretary, the treasurer, the president, that doesn't mean you have to be the one that actually takes the minutes if you're the secretary. Okay. The flip side of that is you're still bound to do what you're supposed to do. So, for example, if you're the board secretary and you have a professional management company that you've contracted with to take the minutes for the association's board meetings and membership meetings, you as the secretary may have the management company do that, but you have to still, as the secretary, ensure that it gets done. So it's not a sufficient answer to say, Fran, I was the board secretary and we hired XYZ management company to do that. And the minutes were never done. Minutes were never passed. Minutes were never finalized. Minutes were never posted to a website. And it just didn't happen. People are going to come back to you as the secretary and say, wait, that's your responsibility. And even more so, the role of the treasurer, right? So if the association's management company or management staff is keeping the books and records of the association, reconciling bank accounts, reconciling check accounts, doing things like that, investing the association's money, it's not a sufficient answer if you're the treasurer to say, well, we hired a management company to do that. No, the treasurer should still be involved, at least on a monthly basis, verifying that those things get done. That does not mean, however, that you loom over the back of your bookkeeping staff or change GL entries on a daily basis, or you have to approve payroll on a daily basis. No. But as the treasurer, if you have a professional management staff or a management company, you do, at the end of the day, have to do what is reasonably necessary to verify that the proper things are being done, right? One of the claims that we get in fraud cases is the board was contributorily negligent to the funds being taken because nobody on the board ever looked at a bank statement. Nobody ever looked at a bank reconciliation. Nobody really ever looked at the invoices and the payments, etc. And the wrongdoer just went wild on their own. Okay, and sometimes that went on for years, unfortunately, right? So that's the president, the secretary, and the treasurer. I showed you the bylaws, the sample bylaws there. Removal. So people keep in mind, there are two removal issues. One, you may be, if you're appointed to an officer position by a vote of the board, you can be removed from your officer position by a vote of the board. Many times people are confused with that because removing you from your officer position does not remove you from the board itself. Does that make sense? And a lot of people think, hey, you were the president, there was an uprising, and we removed you from your president's seat. Now we're going to fill your seat on the board. That's just not the case. Just like this fellow the other day, I think, who was removed from he was the Speaker of the House, is not removed from Congress, right? He's just not the Speaker anymore. So you can't remove somebody from the board who was elected by the membership. If you have this is really strange. I don't even know if I've ever seen them. Some bylaws, especially corporate bylaws, may say that the president with the officer positions are voted on by the members themselves. So they're designated as that type of election. If the members actually elect who the president is, then the members have to be the one removing them. But in the association world, I have never seen that type of provision. The removal and the appointment are within the power of the board itself. And removal is generally with or without cause, So it's not like the other board members, if they're removing you as a president, removing you as the treasurer, the secretary, what have you, they have to say, and we're removing him for the following reasons, blah, blah, blah. No, they can just say, we don't want you to be the treasurer. We don't want you to be the president anymore, etc. For those of you who've known me for a long time, I was involved in an organization where I was removed as basically the president-elect / president of the organization because I just did not see eye to eye on some issues with that organization. And I was not removed from that board. In fact, I served on the board for another 2 years, which is fine. I have a couple removal cases going on right now in terms of officer removal matters. The fact that you're removed from your officer position does nothing to diminish your opinion on the board or your vote on the board. Can it be embarrassing? Yes. Can it hurt your feelings? Yes. Do you feel perhaps unhappy with your fellow board members? For sure. But it does not diminish your role on your board. You still have your one vote. You're still entitled to voice your opinion, make motions, etc. So just because you've been removed from your officer position does not mean you can't entirely contribute just like you did before on the board itself. Setting the tone on the board. So the president generally is the one who sets the tone of the board because she or he presides at the meeting. Just going to give a little space right there. So I'll say it again. The president is generally one who sets the tone of the meeting. As the president, if you don't handle setting the tone properly, all you will have at every meeting is angst, right? Or you will have angst at every meeting. That does not mean that you won't have hostile people coming to the meeting and being hostile toward the board. But as the president, you have to be, notwithstanding some of the recent presidents we've had here in the United States, you have to set a tone that is presidential. Because if you don't, members will regularly bait you into screaming matches with the membership. And that is a huge mistake. You do not want that. You are the president. You are the presiding officer of the organization. You control the meeting. You set the tone. If you have to, we don't like to do this. You can close the meeting if you have to. For those of you who have worked with me, I don't like to see the gavel. I think the gavel is a mistake. I think it just makes things worse instead of better. I think people, especially people who are involved in these types of civics activities, are more than able to work civilly, even though they disagree passionately. But that being the case, there are times I'd much rather see the meeting closed or the meeting adjourned if you have hostile people in the audience than have the board president looming over the board table in a shouting match with residents. All that does is put egg on the board member's face and gives ammunition to the screamers in the audience, and actually more often than not works to their benefit. And especially in the world of this thing, right? 9 times out of 10, when the board president loses her cool or loses his cool, you're going to have somebody with a camera there posting it 15 minutes later, showing how Mr. Board President was screaming at the audience, right? So that's not going to help you because you have the title. You have to be the one who's cool. Executive directors, general managers, and manager staff. So keep in mind that there's a big difference between the board members, the officers, and the executive director, general managers, and management staff. The board should set policy. You've heard me say this a million times. The board should set policy. The executive director, the general manager, and the management staff should implement that policy. They should be handling the day-to-day affairs. They should be implementing the board's policy decisions. The board members, unless you're 100% self-managed with no management staff and no management company, should not be doing things in terms of day-to-day business. That undermines the leadership of your management team and makes things very difficult and very confusing for your employees, if you have employees, or for your management company, if you have a management company. This is especially true if you have a quality property manager, because quality property managers really, really want to manage as part of their careers. And the last thing they want to have done to them is be turned into an administrative assistant by the board members who are telling them how to lick envelopes. Okay. It's a big mistake, and you'll wind up losing quality management that way. All right. Legal liaison. So legal liaison, as an attorney, you know that oftentimes the board wants to talk to counsel over various things. So the legal liaisons are generally the lead property manager, right? And 9 times out of 10, the board president. Doesn't have to be the board president, but 9 times out of 10, it is the board president. And that's usually appropriate. Keep in mind that to the extent you're able to, you should limit who goes to counsel, right? And the reason for that is us attorneys, we bill, and if you have 5 or 7 board members banging out calls to the attorney, you're going to get big attorney fees, right? You're going to get big attorney fee bills, and you don't want that. Now, certainly, as attorneys, we do get calls from alternate people. So we'll have a trustee who is not an officer reach out to our firm sometimes and say, we think the majority of the board is doing a wrong thing. Well, we have to address that at that point, or doing an illegal thing. We have to address it. It's always a balancing act, though, because most of the time when those people reach out, we do say, hey, the legal liaison is the board president, or the legal liaison is your lead property manager. Please have her or him reach out to me, because we can't bill for this stuff just chatting with every other board member. Okay, so that's the legal liaison. Agenda, books, records, and financing. As I said before, the books and records and finances, they are the bailiwick of the secretary and the treasurer. And just because you have a management company or a management staff, it's not wholesale delegation to them. Your duties as the treasurer and the secretary remain, and you have to verify that the people who you've hired to do that work actually do the work. So you got to make sure the books and records are being kept properly. You have to make sure the minutes are being kept properly. You have to make sure the resolution books are being kept properly. You have to make sure the contracts are being kept properly. Okay, so that's important. As far as the agenda is concerned, generally speaking, and with Radburn, especially under the regulations, is you're supposed to put out there an agenda that reflects the known items to be discussed at the meeting. Now, that doesn't mean that all items must be on the agenda, but if they're known prior to the meeting, they should be on the agenda. Generally speaking, the board president sets the agenda, but other members of the board can request that items be listed on the agenda. So that's the agenda, the books and records. Now, apparent authority versus actual authority. This is a big issue in associations where you have very dominant board presidents. Just because a board president has the title of board president, it does not mean that he or she can just go out to a landscaper and say, cut down those 20 trees and replace them with dogwoods because I love dogwoods. No, the board president just doesn't call the shot just because she or he says so. Does that make sense? The problem with that, however, is there are times when a board president will do that, and the vendor will then present an invoice for the $20,000 after everyone goes nuts because the trees were cut down. And the vendor says, well, she or he had apparent authority. Right? I knew she was the board president, or I knew he was the board president. So when they told me to do that, I thought that made sense. And now you owe me 30 grand. And the board says, we're not paying that. The board never voted on that. And the landscaper goes, well, wait a second. I did the work. I finished the work. It was asked for, and I truly believe that the board president was authorized. So you have to be very, very careful. The case law is very fact sensitive on that. The board president can bind the association via apparent authority, especially if there was a course of dealing. So if over a course of years, the board has been relatively passive and the board has allowed the board president to direct landscaping activities, in my example, and the board president has always said, landscaper do this, landscaper do that, landscaper do this, then there's very great likelihood that even though there was no vote, the association via the vendor is probably going to be stuck with the contract or the work or the bill because of apparent authority. If a vendor tries to enforce a contract just because he or she was walking around the community and the board president said, yeah, we're gonna have you do the paving work, and then that vendor says, I insist to do the paving work because the board president told me I was going to get the paving work. Well, that's not binding. That's not binding, right? Um, so be very cautious about that. Certainly, if you as a board vote to empower the board president or the treasurer or another person on the board to do certain things, that's fine, and you're able to do that. But otherwise, be very cautious. And if you are a board president, be very cautious to act within the scope of your authority and not exceeding it. Okay, there's a number of questions in the chat. It is a good idea for the treasurer with one other board member's signature to hold the reserve and not the management company. So, it's a question. Is it a good idea for the treasurer with one other board member's signature to hold the reserve balance and not the management company? So, and I've never seen that. I've never seen the individual board members hold reserve funds. I mean, perhaps in very small communities and you're 100% self-managed, I imagine. But my experience has been that management companies, if they're in place, they will do the bookkeeping work for reserve funds and operating funds and deferred maintenance at the direction of the board, though. So the board has to direct, and the board members, if they want to, can control that via signature authority. The question, if you're going to make a move with respect to signature authority, is ask your financial institutions who has signing authority on the accounts. Because I've had a number of instances where former management company personnel still had signature authority on various bank accounts. Past board members still had signature authority on bank accounts and other financial things. And that can be a little scary, right? That can be a little scary. We've had incidents where we've had to go to the banks as, we'll say bad management company was transitioning out and good management company was transitioning in, and the bank was giving us a very hard time in terms of shutting off that signature authority. So you just have to be careful and make sure you're aware of who has signature authority. Jeff has a note on vacant units. For the vacant units, especially for snowbirds or extended vacations where the heat was turned off, the insurance company may consider that negligence and deny coverage. He says it happened to an owner in one of his associations. For those of you know, Jeff is a vice president with Taylor Management. It says he happened to one of his communities. Owners did not have insurance, relying on the association insurance, had to pay $40,000 out of pocket. So that's a big hit, right? That's a big hit if you have that type of loss. Should a board member be camping in the community manager's office on a daily basis? What can be done if with fellow board members when one refuses to stop doing the same? So Al, and you've probably heard me on this many times, I don't know why a board member would be in the association manager's office on a daily basis. It just shouldn't happen. As you know, we're being recorded on this. I don't always say the most politically correct thing, but the fact of the matter is, whether you like this as a political matter or not, the board president should not be in the management office, the manager's office every day, hovering behind the manager's back and dictating what's happening in the association day to day. I mean, I've had board presidents who even have said, "I will do your job. I will do your job," and it hurts my ears when I hear those types of things because it's a recipe for disaster in the management office, right? And you're going to lose, any self-respecting, especially high-level property manager is going to ultimately leave, right? Because people who are good at their job want to do their job, right? They do. They want to be trusted. They want to have faith. They want to do their job. Under the new Radburn regs, a board member can be removed by a majority of the board, but under some conditions, ADR has to be offered. Does the question, DCA defines ADR as a non-binding, but the regs say that the ADR finder has to provide conclusive evidence that there was cause. How do we reconcile the conflict? So thanks for the question, Chuck. So it's not the difference between binding and non-binding. So I see ADR as non-binding. As you know, and if I haven't said it before on First Friday with Fran, I'll say it here. We recommend against boards removing board members under that Radburn provision. The reason for that is, I believe it's the Ocean Towers decision, where there was dispute where they removed a board member, the board member fought it, and the association's insurance company wound up having to pay the attorney fees for the board member who was removed, but for his fight to say that his board removal was wrongful, right? So the association wound up paying hundreds, or the carrier wound up paying hundreds of thousands of dollars, fighting the fight for the person who had been removed. So I would leave that decision to the membership, even though Radburn allows for it. That's number one. But the ADR provision that Chuck's referring to is, it's not so much a binding thing. It's that the ADR provider would only uphold a removal, I guess you would say, would put his or her blessing on a removal if they made specific findings. So the default provision is if the ADR provider does not make such a finding in those two circumstances, Chuck, the person remains on the board. So it's kind of weird. I guess you could call it binding, but under, I forget what the two circumstances are. I don't have Radburn in front of me. But if in those two circumstances, the ADR provider doesn't make a finding, the person remains on the board. It's a very odd provision. And some of these things are going to be amended. But that's a really good question, Chuck. I think I think it puts the ADR provider in a very awkward position. And as you know, I do lots of ADR and lots of mediation, puts the provider in a very awkward position. Do Robert's Rules of Order trump bylaws or state laws? And can a president make a motion? So that's a good question, Lizette. So I'll show you. Maybe I anticipated your question. So here's a copy of Robert's Rules of Order, right? Robert's Rules of Order with comments. And I had recently someone came up to me and said, the association's governing documents say that the association is bound by Robert's Rules of Order. And some governing documents actually say that. And how I interpret that is Robert's Rules of Order are guidance. They're guidance tools. The governing documents, Master Deed Declaration and bylaws are what bind you. And, if push came to shove, a court may look at Robert's Rules of Order to interpret ambiguity in the governing documents, in the bylaws, etc., and may find that they're binding, right? So that's possible. The question is, can somebody insist, if someone called me today and say, hey, Fran, our documents say that Robert Rules of Order govern how meetings should be conducted, etc. Is that binding? Do I have to abide by that? And what I say is, this copy of Robert's Rules of Order is, with comments, is 669 pages long. 669 pages long. So I say, if you really believe that, what you're going to have to do, in addition to hiring me as your lawyer, is hiring a full-time parliamentarian for every one of your meetings to discuss whether a point of order can come up and in what context the point of order comes up and in what chair somebody sits at the actual meeting. Robert's Rules of Order addresses those things, right? Who sits in what chair, and should you have a separate lectern for the non-chair of the meeting, and on and on and on and on. And I don't think it's anyone's intention that Robert's Rules of Order put a straitjacket on the association. That's not to say that Robert's Rules of Order can't be a good guide. I do use Robert's Rules of Order, especially when the bylaws are not real clear and people especially we'll say, I hate to use this word, but misbehaving in meetings. I do use Robert's Rules of Order as a reference source to say, listen, chaos is never the answer. If you want chaos, you can't have chaos. I'm sorry, sir, or I'm sorry, madam. Chaos is not the answer. And I will show you Robert's Rules of Order as an authority for the fact that things should go a certain way and we're going to loosely apply them. Can the president make a motion, and can the president vote on a motion? So generally speaking, if you, I don't have the section of Robert's rules in front of me right now, but generally speaking, a president doesn't vote, if you want to look at it in the typical sense, doesn't vote except to make a tie or break a tie, make a tie or break a tie. And the reason, I think the theory behind that is people like to have the chair give the impression that she or he is above it all. I'm above. I just sit here in my grandeur, like the president of the Senate. I just sit here in my grandeur, and the Senate fights it out, and they all get down in the mud. But if push comes to shove, I can make a tie and stop the motion, or break a tie and have the motion go forward. I have that power at the end of the day. But unless there's a potential tie or a breaking of a tie, I, as the president, am above it all, right? I'm above it all. So that's the make a tie, break a tie. As far as making a motion under Robert's Rules of Order, again, loosely, I would say yes. I don't know what Robert's Rules of Order says on that. They may not. I mean, typically under Robert's Rules of Order, the president or the chair would call for a motion. I would like to call for a motion today to hire blah, blah, blah as the landscaping company. Generally, the chair does not make motions. But again, in community association world, many times the chair makes the motion, right? And the reason for that, many times the chair or the president is most familiar with the issue, number one, and usually he or she is most comfortable speaking in front of the membership, if that makes sense, right? So there are a lot of associations where the president is the person who speaks most in public, and the other trustees are more than happy to serve as trustees, but the last thing they want to do is speak from a dais somewhere. Does that make sense? So it's not like the president is revealing this crazy bias. It's more or less just a practical matter of getting the motion out there. I have some associations where, again, I think Robert's Rules of Order would probably say the chair calls for a motion rather than making a motion. But I have some associations where they operate that way. The chair doesn't make motions, but calls for a motion. And in those cases, I've actually seen some of those associations where the motion is written out in a script before the meeting, just so the other trustee who doesn't normally speak is comfortable making the motion, reading the motion that everyone is familiar with. There's not a problem with that either. It's just becomes somewhat cumbersome for management and the other people on the board, because then you have to, your meeting comes off somewhat scripted, because it is scripted in that regard. But I don't think it's either here nor there. I've never seen a motion or a board vote overturned because the chair actually made the motion. What is supposed to provide rules? What is supposed to provide rules besides bylaws governing HOAs? What is supposed to provide rules beside the bylaws governing HOAs? So, as I said earlier, thanks for the question, Sharon. What is supposed to provide rules other than the bylaws? As you saw on today's agenda, so there's New Jersey Nonprofit Corporations Act, which governs, and that's binding law. There's binding law in the Condominium Act. There's binding law in the Planned Real Estate Development Full Disclosure Act, and the Radburn statute and regulations are embodied in the Planned Real Estate Development Full Disclosure Act and regulations. So, and on top, an overlay to all of that stuff, Sharon, is case law where judges interpret those regulations, they interpret the bylaws, and they interpret how they should be applied in the real world. Because as you've heard me say many times, whether it's the Department of Community Affairs or the New Jersey legislature, who may have the best intention in the world when they pass their legislation and their regulations, in the real world, things are often different. Things happen that they can't anticipate. There may be gaps in the laws or regulations. Nobody can write, the best lawyer in the world can't write bulletproof language. You try to have bulletproof language, but that's what the judges are there for, to address that. So Sharon, what you would see would be case law interpretations, and that's why I kind of opened the discussion of the Nonprofit Corporations Act with, if you're doing research under the Nonprofit Corporations Act, often you will find very few cases, if any, referencing particular sections. You have to go back to the For-Profit Corporations Act and then argue by analogy, hey, this case controls because the language in the statutes are virtually the same. Can boards meet monthly to do business and then only meet quarterly to ratify the votes in front of the association? No, 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 no. I spend my life saying no to that question. The way New Jersey, and this is even before Radburn, this is before Radburn. Everyone says Radburn made this happen. Yes, they made it much more express and explicit, but boards were required to make their binding decisions and open already. So the decision must be made in a meeting open to the membership. A binding decision must be made at a meeting open to the membership. You see what I'm saying? It can't be, hey, hire ABC landscaper. Great. You sign a contract, and then 3 months later you say, I make a motion, we hire ABC landscaper. It's not appropriate. Lots of associations do it. They feel it's too cumbersome to meet monthly or to meet as needed to make the votes. But the fact of the matter is the law applies. And I can tell you that the Department of Community Affairs has been more and more active in terms of responding to complaints with respect to associations who don't make their decisions at meetings open to the membership. That does not mean that anyone must attend your meetings, right? They just have to be on proper notice. The notices have to go out and they have to be in a forum where you can have a meeting where people can actually attend, and they have to have the opportunity to attend. They don't have to be there. Our HOA Budget and Finance Committee reviews the monthly reports, which have been prepared by management company. Reports to the treasurer, reviews monthly reports. Yeah, that's great. I like that. Our HOA Budget and Finance Committee reviews the monthly reports, which have been prepared by the management company, reports to the treasurer, and reviews the monthly reports. That's great. I can say that in many of the active adult communities, there are fantastic finance committees, really fantastic finance committees. And generally they draw on people who have spent a lifetime in finance and accounting. And there are a lot of those people out there, and it's great that they volunteer their time. So thanks, Ed. Which document takes precedence between the bylaws, Robert's Rules of Order, Nonprofit Corporations Act? If bylaws say the officer election is held annually and the board decides to have an election mid-year. So there's a lot to unpack in there, Sharon. So generally speaking, the Nonprofit Corporation Act would take precedent over all of it, except that many provisions in the Nonprofit Corporation Act say unless the bylaws provide otherwise, the following shall happen. The reason for that is, in many respects, the Nonprofit Corporation Act is a backstop for provisions that may not be contained in your bylaws. Basically, although some people may not believe this, the legislature doesn't want to be in the business of actually running your company, even though they do want to regulate it. So generally speaking, the state law or federal law would apply. So for example, when we talk about laws and statutes, and those of you who have been here lots of times on First Friday know that in the context of handicapped accommodation, it doesn't matter what your declaration or master deed or bylaws say, you have to accommodate handicap. It doesn't matter what your governing documents say with respect to handling protected class status. If there's a protected class status person, that person is subject to those statutes, and those statutes trump everything in your governing documents. So for those of you who are as old as me now, they know that some of those old documents contain things like right of first refusal. The right of first refusals generally don't apply, right? Right of first refusals in associations don't apply, even though they may be in your master deed or declaration. The reason for that, again, for those of us who are old enough to remember this stuff, is that what they would be used to do as a right of first refusal to the association would give the association the opportunity to purchase a unit instead of having someone that they don't want move in and purchase the unit. So that's why they're presumptively void. Okay, so generally, Sharon, the statutes trump. Then the next would be the bylaws themselves, and then Robert's Rules of order would be third, generally speaking. When board president prefers not to chair the meeting, delegates the role to management, could another board member, secretary, or chair the meeting? So yeah, sure. Another board member can chair the meeting. Yeah, I think so. I mean, generally speaking, the chair should chair the meeting, or, again, if we're looking at Robert's Rules of Order, Robert's Rules of Order would suggest that the chair has to chair the meeting if the chair's there. If the chair is not there, that would devolve to the vice chair or the vice president, right? So that's what typical rules of order would be. Thank you, Anne. Thanks for attending. The issue at board is controlled by the sponsor right now. 3 out of 4 board members are appointees by the sponsor, the same executive wearing 2 hats. So yes, so Marcos, even if it's a sponsor-controlled board and the sponsor person does not want to chair the meeting, it's not unusual for the homeowner to chair the meeting, even if the homeowner was appointed by the developer. So that's very, very common, Marcos, as you probably know. Are term limits appropriate for board members? So that's a really good question, Anna. And we could spend a couple minutes on that. Are term limits appropriate for board members? In a practical matter, I personally am not in favor of term limit for board members, and here's why. In many associations today, it's extraordinarily difficult to get competent volunteers to serve on the board. And what I have seen happen back prior to Radburn, I had several communities in Ocean County amend their bylaws to enact term limits because there had been people on the board for a long time and people thought they were on the board too long. So they imposed term limits. Those people had to leave the board. And what happened is several years later, they could not get sufficient volunteers, and they actually removed the restrictions on term limits so that some of those people could get back on the board and run the place. So that's one issue with term limits, just as a practical matter. The other issue with term limits post-Radburn is Radburn says the only qualification for running for the board and serving on the board is to be a member in good standing. So Radburn doesn't say, and you must not have been on the board for two of the past terms. You see what I'm saying? So if someone said, Fran, how do you apply Radburn to term limitations, even if they are in the governing documents, I would say term limits don't apply because Radburn does not permit them. Does that make some sense? See what I'm saying? Radburn says, this is your qualification, period, end of story. I think an imposition of amendment that would have term limits would probably be stricken. Al says he agrees. Anna says, thank you. Right. Jay says the way to limit terms is to elect a different person, which is true. So the argument for term limits in, we'll say, public government, whether it's municipal, state, or federal, is that during the tenure of a sitting board member, that person, in theory, could glom enough control over the levers of government and financing such that they could make themselves electable for life, right? So that's the old political machine, whether it's the Democratic or Republican Party, you form a political machine, you have enough crony politicians under your wing to control all the divisions and the departments in government, and you flow all the fundraising and finances of the state or the country or the municipality to your party or your group, right? I have not seen that in community association world. I have not seen that in community association world. I have seen it in local politics, and of course, we've probably all seen it at the state and federal level. Again, regardless of party affiliation, machine politics happen. The argument for term limitations, I think, is stronger there. But I am still not a big proponent of term limitations. The scary part about people who do glom the levers of government at the municipal, state, and federal level is it's true that they can sometimes become almost impossible to remove that person from the position. And I think the most glaring example of that was the guy who was I think he was the mayor of Jersey City in the 30s and 40s and 50s. I forget what his name was, but people said, hey, this guy is the king, basically, of Jersey City. And then later on, I think there was a situation in Chicago which had a similar outcome, where the mayor of Chicago basically had a death grip on the mayoral seat. So, I mean, the argument may be better there, but I still think the voters should vote. Is there a punishment of some kind that the Department of Community Affairs can implement if an HOA makes decisions not in an open meeting? So yes, yes and no, Lori. The DCA under the new reg says that it can impose fines and penalties on associations for failure to comply with the Planned Real Estate Development Full Disclosure Act. I haven't seen anyone fined so far for that type of thing. I think it's coming. I think it's coming. Because I think at some point the DCA is going to find an association where the board is so intractable and won't do things the right way that they'll feel, number one, compelled to act, and number two, find an association that is such a poster child for that they'll use that association to make an example for other associations throughout the state, right? So there's nothing the DCA would help the DCA's cause in having open public meetings more than having a nice appellate division or Supreme Court case on an association who refuses to abide by Radburn and the enforceability of the penalties. So there is an issue, and I think this is probably true, that the DCA regulations go beyond the scope of the Radburn law. And I think there's some debate over whether or not the DCA has the actual authority to fine under the regulations. But put that aside, I think you will see the DCA at some point finding a proper test case that they think will be a win for them, more or less, so that they can take a case up and show to the rest of the industry that if you don't do the right thing, the DCA is going to take care of business on that. It would be unfortunate and a waste of money for the association, because it's not that difficult to do the right thing. And it's also a good thing to do the right thing from a policy standpoint. If Radburn or another regulation supersede the bylaws, then why bother with the bylaws? We are to basically follow a combination of other state regulations. So the answer to your question is the statutes are, in this world, in this industry, if you will, tend to be a backstop on association conduct. Notwithstanding that, there is a level of self-control under the bylaws, so the board can still organize themselves, but still within the framework of the statutes. And then again, as I said, Sharon, even then courts make decisions which change the interpretations of the bylaws and even the state regulations themselves. Okay, so Ray Barton comes up with Haig. Yes, Haig, the mayor of Jersey City, right? I think he built Jersey City Medical Center, which had, I don't even know how many vacant beds in it, but it provided a lot of jobs during the Depression, right? Built a lot of the Jersey City Medical Center. It was a beautiful building, and now is really nice condos. So yeah, the Jersey City mayor was Frank Haig from 1917 to 1947. Thanks, guys. That was Wayne. Nice to see you, Wayne. Thanks. Let's see. That looks like about it. It's about 4. Well, we're getting close to 5 o'clock. So thanks so much, everyone. I hope you have a great weekend. I hope you don't get too much cold and rainy tomorrow. And I will see you in November for Turkey Day. All right. Have a great Halloween. Have a happy Halloween. I'll see you at Thanksgiving. Have a good weekend. Bye-bye.